Being made redundant is one of the most stressful things that can happen in your working life. But here's the thing, your employer can't just let you go without following certain rules. In this video, we're breaking down exactly what your rights are, what your employer must do, and what happens if they get it wrong. Redundancy law in the UK is more detailed than most people realize. There are rules around consultation, selection, notice, and pay. And if your employer cuts corners on any of them, you may have grounds to challenge the decision. So let's go through it step by step. The first thing to understand is your right to consultation. If fewer than 20 employees are being made redundant, your employer must consult you individually. That means giving you a genuine opportunity to understand why you've been selected and to explore alternatives. Things like reduced hours, flexible working, or relocation to a different role. If 20 or more employees are at risk, the rules go further. Your employer must consult employee representatives, such as a trade union official, on behalf of those affected. In both cases, this isn't just a box-ticking exercise. If proper consultation doesn't happen, the redundancy could amount to unfair dismissal, and that means you may be able to take your employer to an employment tribunal. However, in most cases, employees can only bring an unfair dismissal claim provided they have a minimum length of service. Currently 2 years, but this is reducing to 6 months in 2027. Next up, how your employer selects who is made redundant. This selection process must be fair and based on the genuine needs of the business. Employers can take into account things like your skills, experience, disciplinary record, and performance in the role. What they cannot do is factor in personal characteristics. Selecting someone because of their age, gender, race, disability, sexual orientation, religion, working pattern, for example, because they work part-time, or because they are a trade union member, is unlawful. In those cases, the dismissal may be discriminatory, or what is known as automatically unfair. You're also entitled to notice before your employment ends. This will be the longer of your contractual notice period or the statutory minimum notice period. The statutory notice periods are 1 week's notice if you've been employed for more than 1 month but less than 2 years. 1 additional week for every year of service between 2 and 12 years. 12 weeks notice if you've worked there for more than 12 years. Your employer may bring your employment to an end sooner than your full notice period, but must then offer you a payment in lieu of notice instead. Now let's talk about money. It's worth remembering that legally speaking, it's your role that becomes redundant, not you personally. And if that role disappears, you may be entitled to redundancy pay. There are 2 types. Statutory redundancy pay is the legal minimum, calculated based on your age, your weekly earnings up to a statutory cap, and how long you've worked for the employer. To qualify, you need at least 2 years continuous service since the age of 16. Contractual or enhanced redundancy pay is anything your employer has agreed to pay on top of that. This may be a contractual requirement, so do check your contract and policies carefully, or a case of your employer exercising their discretion. One important point, you should not have to chase your employer for this money. It should be paid automatically on or shortly after your last day. If it hasn't been paid within a reasonable time, write to your employer to resolve this. Bear in mind that if you end up needing to bring a claim, the usual time limits are 3 months and 6 months, and you need time to go via ACAS first, depending on exacting what you are claiming. Redundancy can feel overwhelming, but the law gives you real protections, including on consultation, on how you selected, on your notice period, and your pay. If any of those haven't been followed, you may have options. If you're unsure where you stand, speak to Duncan Lewis as early as possible. The sooner you get advice, the more options you'll have.